course, facing domestic accountability for international crimes. I think this excellent panel, they've documented it very well, from the challenges of having available witnesses, insufficient evidence collected at the investigation stage, and of course, the lack of political will, which is often the unwelcome elephant in the room. So what I'm going to try and do with my few remarks is to talk about some of these challenges and just some of the ways that we could, thinking strategically, try to address them. So, as we know, some successful domestic prosecutions have occurred largely after the fall of the respective government, right? And certainly with immense domestic and international pressure from civil society. An example, and I'm going to be giving examples with respect to sexual and gender-based violence. So an example is in 2016, where a Guatemalan court convicted 2 former military personnel of multiple crimes, including sexual violence, sexual slavery, domestic slavery that were perpetrated against women from an indigenous community that were living near an outpost, a military outpost in Zaco during Guatemala's civil war. Now, the civil war lasted 36 years. And the incidents in question took place in the 1980s. And so you can see, obviously, how long it took for these women to get justice in 2016. This case, however, marked the very first time that you had convictions of former military officials in Guatemala for sexual violence committed during the country's armed conflict. And it was also the first instance where a domestic court had applied both national and international laws to prosecute sexual slavery as an international crime. And of course, we have the example of Hissène Habré that was mentioned by Stella, I believe it was Stella, in the first panel. So I'm often reminded of this statement by Martin Luther King that we shall overcome because the arc of the moral universe is long and it bends towards justice. What I take away from that, especially in the context of the discussion today where we talk about how long justice is taken, is that challenges such as the lack of political will do not last forever. And of course, we know that political will influences international justice. The key question for us who care about accountability is how do we navigate that? A very common saying in Nigeria is no condition is permanent. In fact, that's how I grew up, that mentality of no condition is permanent. Omar al-Bashir once believed that his leadership was secure, but as we know, his fate shifted. The same was true for Hissène Habré. And of course, the same was true for the military commanders in Zaco case. And I believe that the same will be true for those who are perpetrators of the crimes going on in Sudan and in other places in the world that we are talking about today. So when we recognize that no situation is unchangeable, we must continue to take the action today, like planting the seeds today, that will bear great fruit tomorrow. So just as the last speaker mentioned about continuing to document, continuing to strategize within your network. Even if a case cannot be brought in a particular jurisdiction, can it be brought in a domestic court elsewhere that might be willing to adopt the principle of universal jurisdiction? Even if the case cannot be brought today, can we collect and preserve evidence in a manner that it will last the test of time? And so then this connects to the next significant challenge that often comes up. And this applies whether we're talking about domestic jurisdictions, international cases, and this is the availability of witnesses. And there are many different factors that impact the availability of witnesses, not just the passage of time. So of course, you can have witnesses who may be unwilling to participate in the process. And where you have a case that is overly reliant on testimonial evidence, then you run the risk of, well, your case being negatively impacted. And so as we aim now to build cases that can last the test of time, let us also think strategically about other forms of evidence, documentary evidence, forensic materials, financial records. These could all help to substantiate the crimes, even sexual violence crimes. And with that, I think it's also important to mention that inasmuch as we talk about sexual and gender-based violence, oftentimes we immediately think about rape or forced marriage. These indeed are forms of sexual and gender-based violence. However, they're not the only form. The forced recruitment of male children is a form of gender-based violence. The killing of men can be a form of gender-based violence. So it's important for us to think strategically about the evidence that we're collecting and we're looking for, because we may just see that there are gendered narratives in the ways that certain crimes that we may think are ordinary crimes like murder, but it has been committed following or pursuant to a gendered narrative or a certain policy to attack on the basis of gender. And so some kinds of evidence that we may think about beyond actual witnesses, for example, with Boko Haram in Nigeria, there were records of shipments of sex enhancement drugs. What could that tell us? We also had with ISIS in Syria, where you had logs and documentary evidence that were detailing the enslavement and sale of Yazidi women and girls. Also, you could have videos of captives performing domestic chores. That could be showing you some kind of evidence of some form of sexual gender-based violence. You could look at images of dead bodies. If you focus only on the dead bodies, you might miss that there are objects next to that dead body that could suggest the occurrence of a sexual attack. And so, of course, thinking again about documentary evidence was very key in the Hussein Habre case. So broadening the scope of the evidence that we're seeking to collect can certainly help us build stronger and more enduring evidence of the crimes that are still going on today and have happened in the past. And I think the final remark that I will make concerns what I will term strategic case building and strategic advocacy. So we should definitely always keep our eyes on the main perpetrators of the crimes and continue building cases through the traditional paths. But some successes have come about from thinking broadly, one, about the characterization of the crimes and using whatever legal framework is available, and then also thinking broadly about the host of perpetrators that we can hold responsible for these crimes. And so I'm going to elaborate with a few examples, petrified that Bettina might tell me I have 1 minute left. Am I okay? Okay, good. All right, so real quick. In Nigeria, unlike Kenya, has not domesticated the Rome Statute. So federal prosecutors do not have the international criminal framework at their disposal. So what did they do in trying to think strategically and to try to put an end to essentially a legacy of impunity where Boko Haram was committing sexual violence without any kind of accountability? They successfully brought a case using Nigeria's counterterrorism legislation, where they prosecuted SGBV as an act of terrorism, even though there is no mention of SGBV within the Nigeria's Terrorism Prevention Act. Another example is from France, where France applied universal jurisdiction in the case of Kunti Kamara, who is a former militia leader in the Sierra Leone War. And last year, he was sentenced to 30 years for acts of torture and inhumane barbarity against civilians between 1993 and 1994. Now, what was interesting is that rape was not considered a crime against humanity in France at the time the offenses were committed in 1994. So what the Paris Criminal Court did was to characterize this conduct as the crime against humanity of torture. And so in doing so, they were making a significant step in addressing it and actually acknowledging the systematic use of sexual violence as part of the offenses committed in Liberia. And then the final example, I would say, would concern the host of perpetrators. Beyond the direct perpetrators and the masterminds, there are, of course, businesses, companies, financial institutions that are benefiting or in doing some kind of transactions with these criminal actors. I know that there's a panel afterwards that's going to discuss the importance of sanctions and financial investigations, so I'm not going to talk about that. But I just want to give 2 examples of companies that have been found responsible for complicity in crimes, whether in Sudan or in Syria. And so the first is the BNP Paribas, so I'll just say BNP. It's a global financial institution headquartered in Paris. And it is currently undergoing an investigation in France for allegedly facilitating crimes committed in Sudan between 2002 and 2008, particularly in Darfur. And last year, a US court ordered BNP to face a case in US on complicity. And what the argument was that BNP used its banking network to evade US sanctions and was able to finance the Sudan with US dollars. And the practice that it engaged in, the judge said that there are just too many facts, in quotes, too many facts showing a relationship between BNP's financing and the human rights violations committed by the government. And connected to this, BNP actually had to plead guilty to evading US sanctions, and it was fined 8.9 billion US. Sadly, that 8.9 billion US has not entered the pockets of any of the survivors, but what is this showing us? It's showing us that you can hold these institutions responsible. And then the final example is of Lafarge, which is a cement company. And during the height of ISIS operations in Syria, it paid ISIS millions, I think about $6 million, to be able to continue its operations. And these funds evidently enabled ISIS to perpetrate the horrendous crimes that it did. And so last year, French investigating judges ordered Lafarge and 4 former executives to stand trial, basically for financing a terrorist organization that was known to be committing a range of crimes. And it didn't help Lafarge to say, well, we didn't directly finance them to perpetrate these crimes. Like, no, you knew what they were doing and you paid them to be able to continue. So why am I pointing all of this out? These examples highlight the importance of identifying additional entities that can be targeted, whether for judicial proceedings or for sanctions. If we think about Sudan, are there any entities, for instance, that are benefiting from the sale of gold from mines that are controlled by the RSF, for example? Do we have any evidence? Can we work with other partners in justice to identify that? Even if it's not immediately possible to prosecute the direct perpetrators, maybe by disrupting their operations through targeting these other entities that they work with, we can find a way to minimize the crimes that they are committing. And so I'll pause there, and I know that there's another panel that's going to go into that in more detail, but yeah, thank you.